All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. Thank you for joining us for the last webinar of the year. It's Follow the Money, Master Trust for Child Welfare, Children and Youth. Before I introduce our speaker, I do want to go through some quick housekeeping announcements. The training is being recorded, so if you registered, you're going to receive a copy of this recording and the materials from Zoom within about 24 hours or so. If you were not able to register or you want to share with other people that were unable to register, I will drop the link for the playlist that includes all the trainings for this series into the chat as well. You can find all of these on our YouTube channel as well. The training was approved by the Florida Bar for 1.5 General CLE and 1.5 Juvenile Law Certification Credits. I'll announce the CLE code towards the end of the presentation. I will drop it into the chat. You will also find the CLE code in the YouTube description. So there's going to be a lot of different ways to find it. If you need a certificate of attendance or completion, feel free to email me after the webinar. So once I start getting all these emails, I'll start preparing those certificates. I'll probably start sending those out tomorrow when I have more time. So closed captions are enabled for anybody who needs them. So if you're having any issues with accessibility or the captions, you can reach out to me directly. Uh, we have a shared folder for the materials, so I'll drop the link for the materials into the chat as well. That folder will also be included in the email and in the YouTube description as well. And final piece of housekeeping announcements. If you have any questions during the presentation, feel free to use either the chat or the Q&A. I'll come off video and mute to let Robin know in case you missed it if there's a question so we can address it as it comes in. And this training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. If you're not familiar with PILS, I will also include some links into the chat. I highly encourage you to take a look at their website. One of the most active work groups is the Children's Work Group, led by Robin.Rosenberg, our speaker today. So feel free to take a look at that section. So without further ado, you've all probably met or seen Robin in the past, so I'm just going to pass it directly to Robin.Rosenberg, the Deputy Director for Florida Children's First and the Chair of the Children's Rights Work Group with the Public Interest Law section of the Florida Bar. So, Robin, the floor is yours.
Thank you very much, Jorge. Good afternoon, everyone. I'm going to advance our slide, and Jorge is going to pull a poll up for you. So we're well along into our training series, and we're trying different methods of interaction. And the last time we used polls from Zoom, we found out that we could not see the short answer type results. So the polls here today will be multiple choice. It may not be exactly what you would choose for a category, but we'll be able to see who is here today. So while folks are doing that, I want to welcome you all. Florida's Children First is a statewide advocacy organization and now law firm that advocates the rights of children who are served by the state. Most of our work is related to kids in the child welfare system. And the issue that we're going to be talking about today primarily is master trust, which is a right and an opportunity to protect the property of children served in the child welfare system. So I'm going to give the poll just another minute. And in the meantime, let you know that if you are an attorney or a judge and you're not already a member of the Florida Dependency Law Center, I encourage you to join the Florida Dependency Law Center. It's a free online resource with materials, resources, communication tools that is intended to help lawyers and judges who work with children involved in the child welfare system with any party. So not just one party or another, all lawyers involved in the system. So Jorge, can you let us know the results of the first poll? Who is here in the room? All right. Hopefully you all can see. Okay, great. So 65% are attorneys, lots of GALs and other folks. So welcome everyone. Thanks for participating and being part of this webinar. Okay, so our agenda today, where does money come from? Where does it go? And how do children get it? So hope it's not too much of a diversion for you, but we're not jumping right into the master trust issues. We're going to talk a little bit about money for children overall. So master trust is a piece, but there are other ways the kids get money. So where does their money come from? So I want you to think about the situation of work. And Jorge, if you'll issue the second poll. So thinking about the youth that you work with and whatever your capacity is, whether they're a client, whether they're on your caseload, thinking about your teens, are the teens that you work with able to work when they are they able to get work if they want to work? So acknowledging they may not all want to work or be suitable for work, but if they want to work, do they have jobs? And the reason I ask this question is the first way that kids get money is working. And teen employment is normal. And we know that the caregivers in the child welfare system are responsible for promoting normalcy for all young people. So I pulled a quick statistic. 23% of all teenagers in Florida, ages 16 to 19, have some work. So I don't have the statistic for kids in the child welfare system, but having a job as a teenager is a pretty normal thing to do. The citations on this slide are to the what we call the normalcy law or the Let Kids Be Kids bill. And it is both in chapter 409, which is where the licensing and community-based care lead agency statutes are located in chapter 409. And at the same time, it was also almost identical language. It was enacted in chapter 39. So kids that are in out-of-home care in Chapter 39 proceedings are entitled to participate in age-appropriate activities. And I argue to you that that includes working if they want to work. The specific group home rule, 65C 46012, puts the onus on group homes to help children obtain work and ensure that they have transportation to and from the work. So it's included specifically in that statute. And then let's see, Jorge, what are the results of our poll on work? So most don't have jobs, but 26%, that's actually pretty mirrors the statewide statistic. And some of you all don't know. Okay, thank you, everyone. I appreciate your participation in this. Okay, so the next area, and we're going to launch the next poll, is do all the children you work with receive allowance? Because allowance is the second major way that kids receive income, where they get their money. So allowance is this is not limited to teenagers. The question is relating to all of the children that you work with. So allowance is in Florida statutes for all children under 409-14515, where part of developing independent living is a recognition that children need to learn how to directly access and manage their own personal allowance they receive from the department. And they should be receiving allowance from the department. In the administrative code, this provision is relating to children starting at age 13. Also references learning how to use their money through allowance and opportunities to learn how to spend and save. And then it appears, this is a continuation of the previous one that sets out the rules relating to allowance, that it has to be provided at least monthly, which if you work with kids, you will know is really insufficient. But it is also clear that allowance is separate from regulating behavior and promoting chores, requiring chores. And so some basic amount of allowance cannot be conditioned on behavior or completion of chores. Allowance is not to be used for purchasing necessities. The system is supposed to provide their shampoo and basic clothing. It's to be able to buy those extra things that, like you as a parent, would not provide. And it cannot be withheld as punishment. So that's the current rules on allowance. Let's see how you all think about allowance. Can you bring up the poll results, please, Jorge? Okay, so kind of mostly in the middling where some kids get allowance sometimes. So, and this is something for those of you who don't know whether the kids you work with, start to ask them whether they receive allowance. So, Florida's Children First and Florida Youth Shine are promoting a bill this year that would set a statutory amount for allowance, put it in the statutes. Right now, the amount for allowance is not set. Some CBCs will tell you that it's $10 for children 12 and under, that's all children, um, $10 a month, and $12 for teenagers a month. Some give a much greater amount of allowance, some give allowance weekly. What they don't all do is remind the caregivers that the board rate actually includes an amount that the caregiver is supposed to provide to the child as an allowance. Some of the lead agencies are good about telling the foster parents that. Some of them, many of them are not. So the current board rate is already supposed to be used for allowance, but it's not. And this is an area where kids have needs. I have two teenage boys, and boy, aside from what all the necessities that I provide for them, there are things that kids want, and they should be able to buy on their own and budget for and do allowance. So, second way the kids get money. And then we'll take that pull down. Um, the let's see if I hadn't already talked about that. There's specific things in the group care rules. So it's not just that the foster parents are supposed to be providing allowance, the group homes are supposed to provide allowance as well. Same rules, not to be used for their necessities, monthly, not tied to chores, not withheld as punishment. Okay. So the next area of where kids get money from is public benefits. And this is really probably what you were thinking about when you came to a webinar based on master trust. And that is where most of the money that we're going to be talking about comes from, our public benefits. So we don't talk about this a lot, but there are some young people who receive benefits from either the parent being a veteran. We don't have as many coal miners in Florida as other states, but black lung benefits and sometimes railroad retirement benefits. So not often used, but possibly sources of income for young people. The next you may be much more familiar with, and that is Social Security, retirement, disability, death benefits. So, to be clear, these are insurance benefits that are paid because the parent, or in some cases, the grandparent, worked and paid into the Social Security system. This is an insurance benefit. For grandchildren who were raised by their grandparents, they may be entitled to the benefit on their grandparents' record. And when we're looking at DCF documents and accountings, they lump all of these together under the term SSA, which stands for the Social Security Administration. It's really important to note that this is not an asset-based benefit. This is an insurance-based benefit. So it can accumulate more than $2,000 in an account, or the child could have more than $2,000 in assets, and they will not lose these insurance benefits. Um, Derek asks, I'm looking at and you all are welcome as I'm talking to put your questions in. Will the court hold DCF, the CBC to their administrative code? I'm going to take that as oh, the term has escaped me, but uh, not one that I can answer right on a day-to-day basis. And I think maybe turn it back to say, will the people working in the system make the court hold DCF and the CBC to account, right? Um, uh, Most of you here are attorneys. There are motions to compel, motions to, for orders to show cause. Um, you know, I think I don't think as a general basis that people choose to ignore the administrative code or the statutes. I think we have so much turnover, and if things are not at the top of someone's attention, those things slip through the cracks, and it is our job to bring it up. We've been talking about master trust since the early 2000s, and sometimes there's a heightened awareness and everybody's on top of it, and then we don't talk about it for a while and things fall through the cracks. And so, uh, attorneys, guardians ad litem, folks working indirectly with kids, boy, it is our job to to bring these things to the forefront and to ask the court to make people be accountable. So I appreciate that question. Um, and there's someone put a question in the Q&A about how allowance is part of financial literacy and how do we expect clients to get it if they don't get the money. Totally agree with you. It's right. It's not a question, it's an opinion. I agree with you. And that's why at Florida's Children First, we think it's important to elevate that conversation about allowance into statute more explicitly. So it's there. Let's make it happen. And hopefully we can get it put in statute as well. Okay, so getting back to where the benefits come from, the Social Security insurance benefits are an important way that kids get money. The most common way that kids in our system get money is through SSI, Supplemental Security Income, and this is a needs-based benefit. So the children have to meet the child disability standard, and the child standard and the adult standard are different. But the benefit is based on the child's own disability, and there is an asset limitation. If you have too much money, you're not eligible for SSI. We're going to do an entire training on applications for disability benefits further down in our series of trainings. So I'm not going to go into any more details about that today, but there's a lot to dig into. And if you have kids you think should be eligible for disability benefits and you're having a hard time getting them. I see the question in the chat about what master trust can be used for. We will talk about that later on as we get there. Okay, just to have a sense of where those benefits fit into the big picture. This is from data from DCF's current fiscal documents in the Florida Fiscal Portal. So in the fiscal year 24-25, in their trust funds that they have taken in, that big 75% of that is SSI funds. The blue wedge is other Social Security, so the insurance benefits. The gray are income from parents, so presumably child support. And the tiny sliver that's so small is veterans benefits. So, but I want to be clear that while child welfare is almost all of the source of trust funds, DCF does take in trust funds from adults who are in adult institutions. So it's not entirely child welfare, but but I don't know if it's 99%. Most of it is child welfare funds. So that's what we're talking about, the chunk of money that is coming in to Master Trust. And I want to talk to you about how public benefits that we just talked about relate to Title 4E. So Title 4E is the source of reimbursement for room and board for kids in foster care and QRTPs and BQRTPs, so some group homes. And it is source of reimbursement for administrative costs, which fund CPIs, case management, and other administrative costs. Title 4E is a title within the Social Security Act. So Title 4E and SSI and the other Social Security benefits all come under the same law of the Social Security Act. So as a consequence, we have to look at how those things relate to each other when we're looking at the money coming in. So if a child is eligible for Title 4E reimbursement and an insurance benefit under the Social Security Act or Veterans or Railroad Act, there is something called cost sharing. So if in Title 4E, let's say you could receive $500 of Title 4E money, but there is a Social Security death benefit or survivor benefit of $200, then $200 would come from the Social Security benefit and $300 would come from 4E. It is a cost sharing. This is relevant when you're working with level 1 licensed caregivers. So if the level one licensed caregiver is getting the survivor benefit of $200, DCF's payment to them of a board rate will be $300. It will be the difference or whatever it is for the actual board rate. I'm rounding. So that's what happens with cost sharing. In but with SSI, there is no cost sharing. And in the past, DCF instructed the CBCs that they were to elect either 4E reimbursement for room and board or SSI. And the reason for this is it's the same pot of money using federal social security money to help pay for the daily living expenses of a child. And the federal government is not going to pay from two different pots to take care of the same child. DCF has changed its regulations and now directs the CBCs to always elect SSI for those children who are also eligible for 4E funding. So that is for the room and board part. The state will still collect the reimbursements under 4E for the administrative expenses. But between the two, they are now directed always to elect for SSI. And I see in the chat some questions directed at Master Trust. If I don't get to them when I'm talking about it, I will come back to your questions. Okay. And then I'm going to just pause right here to see if there are any questions with regard to the money coming in. Questions or source of money coming in.
The two questions are related to the money, I guess, being used. So
Yep,
I'll
we'll
hold
hold on
off
to
on.
them.
Yeah.
Okay. All right. And you're welcome to come back and ask questions. And again, our contact information is on here. You know, sometimes if it's not relevant to you, you're not going to think of a question, but a month from now, if the issue comes up and you recall I talked about it, feel free to contact me and we can talk about the specifics of your individual kid you're working on. Okay, so we talked about where the money came from, work, allowance, public benefits. Now let's talk about where it goes. So kidding, but not kidding under the mattress, right? If kids don't have a place to safely keep their money, literally they could be putting it under the mattress, right? In a shoebox in the closet, hoping somebody doesn't find it. Not a good result for anybody. So let's hope not to do that. But let's talk about bank account. So Jorge, if you would launch the next poll. So do all the teens that you work with have a bank account? Let's get your information on that. And while you're answering, let's look at the law. So at the judicial review after the child's 17th birthday, one of the things the court is checking in on is to see whether the child has the bank account or at least the information they need to get a bank account. 17 is pretty old, and hopefully your kids are working, getting allowance, accumulating money. I didn't talk about gifts, but of course, people give children gifts. So they can get bank accounts before they turn 17. And in fact, one of the first things that Florida Youth Shine did was advocate for and Florida's Children First is this law, which is the removal of the disability of nonage. That is a mouthful, but it allows teenagers 16 and older to get a bank account without a required adult signature. So, you know, if you have accounts with your kids, you know, you're on uniform custody of minors and all the mechanics that you need to open a bank account for a child. For 16 and 17-year-olds in foster care, that can be waived through this statute. There's a form order in the rules of juvenile procedure to take to the court to get the court order that can be taken to the bank. And then I've also noted at the bottom that there are similar statutes to let kids sign leases, obtain utilities, and motor vehicle insurance before they turn 18. Rosemary asked, can foster parents and parent attorneys see what the financial option details are for a specific child? So th those folks can see the accounting for the master trust that we're going to talk about. Not sure, Rosemary, what else you're talking about. So if you can give me more details, I can maybe answer them more in detail. Okay, so let's take a look real quick at the poll results. Oh gosh, that's disappointing. If only 1 out of 74 say that all of your kids have a bank account. Um, and the majority is, or the plurality, I guess, is a few. So, older kids, it's really important having a stable banking relationship. I know when I opened, my kids had a savings account for a long time, and then when they were old enough, I went to open a checking account, and they told me they don't have checking accounts, they have spending accounts, So, that's again something as you're working with kids, try to keep an eye on because they would benefit from being able to build those banking skills. Okay. Um, let me look at yes, a lot of them have, oh, Venmo, Cash App, PayPal. Okay. In the comments, someone's written in there. I'm old and I stuck with old fashioned things, but yes, there are lots of other ways of moving money around. And those are not done through the court system, so harder to track, but that is the economy today. The second place money can go are ABLE accounts. ABLE is a federal statute that was implemented in Florida. ABLE stands for Achieving a Better Life Experience. I'm not going to go into a lot of details on this, but let's go ahead and launch the poll, see if any of you are working with kids that have an ABLE account. And then, okay, so I've given you the link to Florida's Able United website. It's a state-run program. It's an account that allows people with disabilities to accumulate assets and still qualify for the means-based benefit programs. So you don't, you can have more than $2,000 and still receive your Medicaid. The some of the benefits are so right now, if you have more than $2,000 in a regular account and asset accrual, you could lose your SSI. In an ABLE account, you can have up to $100,000. And likewise with Medicaid, it's not a $2,000 asset limitation. It's 418,000. This is old. That those numbers may be higher. I pulled it from old information. So when kids, if they get a big back payment, if there's another pile of money, this is for kids who have a disability. It is not for every child, but only for those who have disabilities. So the if they're already on SSI or SSDI, which is the disability again on their own account, and that's adults, not children. You can also get qualified with an additional professional if the young person does not already have SSI. So, ABLE accounts were really tricky when they started because they required the a person managing the account to provide their own personal social security number, and it was really unfair to ask caseworkers or guardians ad litem or whoever to give their personal social security number to open an ABLE account. And you'll see in a minute that they have revised the law on that. The reason this money can accumulate and not jeopardize the needs-based benefits is that the money in the ABLE account can only be spent on a qualified disability expense. And this is the list of things that ABLE money can be spent on. That change of law was, I think, last year, and I've given you the operating procedure. So now the CBC lead agency tax identification number is what is provided instead of the individual social security number of an employee. So, Jorge, let's see how many people work with kids who have ABLE accounts. Okay, so 14 of you have kids that have ABLE accounts. And this is just something to keep in mind if you're working with kids who have disabilities and have a little bit of money that can be put away. So, thank you. Okay, let's see. I'm glad you're giving each other advice about fund mismanagement and how to investigate. Okay, so master trust um, is the main place that we're going to talk about where kids' money can be put into. So if you've been paying attention to the news, you may have seen both of these headlines are from this past week. So the Assistant Secretary for Health and Human Services at the Children's Bureau sent a letter to 39 states asking them to stop taking kids' benefits. And in response, you'll see there's an article and the links are below that no, states aren't stealing from foster children. This has been an ongoing campaign nationwide to ask the states to cease taking the Social Security benefits primarily from children who are in foster care or stop making kids with disabilities pay for their own foster care. It's garnered a lot of attention. The 12 states and DCA, whatever, that didn't get the letter are ones that are already working on changing their law. So this is a place where I disagree with a lot of my colleagues in the advocacy field because I think Florida actually has a fair and reasonable system for what we do with children's benefits. So there are some states that take the children's Social Security money. They never tell them that they're eligible for Social Security. They don't tell them how much money comes in. They don't tell them how the money is spent. That's wrong. The money that comes to those children is their money, it is their property, and it cannot be taken from them without due process of law. That's a violation of the Constitution and of Florida's Constitution. But that's not what Florida does. We have had a system in place for a long time where we identify benefits that are coming in. We have the state act as the representative payee to obtain those funds, but DCF and the CBCs are required to provide children with notice and to give them the opportunity to access their own money. So that is what we call master trust. That is our due process regulatory scheme for this money. And so I don't believe that Florida is stealing children's money. Now, I don't believe that everyone always administers our system at the best and highest level. And I really hope that all of you who are participating today and can tell your friends um, will step up your game and put people to the test to do it accurately. But if we use our process, we have a reasonable process. So that's what we're going to talk about now. So these are the main things that the state is required to do. DCF has contracted with the community-based care lead agencies to take on these functions. So number one, to apply for benefits, then to place the funds in master trust, pay itself back for cost of care, plan for the child's needs, give a process to children to apply for funds, and issue the funds to the children or their caregivers when they leave care. So we're going to talk about each of those. Um, the requirement to apply for benefits, I've given you the administrative code provisions that show where it's the case manager's responsibility. There are some states in this national movement that are putting explicitly in state statute that a state is required to, or the child welfare agency is required to screen and apply for public benefits. We don't have that explicitly in the statute, but we have that as a function for caseworkers in these portions of the administrative code. Okay, there's a good question. Is the state double dipping if they're reimbursing themselves from Social Security money and being reimbursed from the feds? No, they can't double dip. This is why they have to choose one or the other. So when they choose for a child to get SSI, they decline the 4E reimbursement for room and board. So they can't double dip. And this is why they have to make the election between the two. They are able still to get reimbursement for administrative expenses, but not for room and board, or that would be double dipping. Are level one licensed homes responsible for applying themselves? No. The case management obligations um, are are not limited to children who are in the legal custody of the department. And this is where that level one gets tricky, right? Because it's a licensed home, just like all other foster parents are licensed, but technically the legal custody remains with the caregiver instead of with DCF. But DCF, the CBC, should still be helping with application for benefits. And to be quite honest, right now, Florida's Title 4E reimbursement rate is much lower than it state anticipated. And so there's a benefit, financial benefit for getting all qualified kids on SSI because there will be more reimbursement if they're receiving a benefit than trying to use the 4E reimbursement. And I'm happy to talk to anybody about that offline, but that's a whole nother topic of conversation. Um, so Heather's question about whether a parent can get child support and a level one placement, that would be double dipping. If child support was coming in, that I think that would be, and you'd have to dig into the operating procedures on uh, on finances, which are some of the operating procedures that are linked in the presentation. You'll be able to find it. And it discusses in detail how to manage all of those things with regard to finance. It might be this 155-7, I'm not sure. Okay, so apply for the benefit. The benefit is coming in. They have to place the funds in the master trust account. They do that by becoming the representative payee for that child. If the child is living with a relative caregiver, then that person will be the representative payee. But if the child is in the legal custody of DCF, as a general proposition, the CBC DCF will make itself the representative payee. This contradicts the Social Security Administration's POMS. That's their rules are called POMS. They set out an order of preference for representative payees, and a state institution is seventh priority. And this is a source of that tension, part of the tension in the national debate about who should be the representative payee. So if the child is in state custody, generally in Florida, the state agency will be the representative payee. This enables an accountability function that would be very difficult to manage if every kid in foster care had someone who was a representative payee, uh, just a member of their family, because there's no way to determine whether if Uncle Joe gets to be the representative payee for a child that's in a group home, how Uncle Joe is using that money for the child. It would be very difficult to monitor. When the CBC acts as an institutional representative payee, there are accounting systems in place and the ability to audit to determine how the money was spent. So this would be a pretty challenging difference if Florida were to adopt what the other states do and not allow DCF to take in the money. The slides will be available. And I try to make sure all the links work in the slides in the PDF so that you can get to those websites. So Master Trust is one big bank account with sub accounts. And if you're new to the system, you don't remember a time when before we had community-based care lead agencies, DCF used to be responsible for all of the master trust accounts. They turned over the responsibility to the lead agencies, so they each operate master trust accounts. Okay, so let's take a poll. Jorge, will you launch, please? Do your kids who have a master trust account always receive notice about what's in their account? This is important. There is an obligation of the state to notify children about their master trust. The obligation has always been in the statute and rules to notify them at least at the time of every judicial review. The report is supposed to be attached to the JR. Recently, DCF amended its internal policies to require that a notice be provided within 7 days of the establishment of the master trust. They created a form called Explanation of Master Trust Notice. Um, it's not a pretty document, but it's intended to be a child-friendly version of this notice, letting the child know that the state has become the trustee and explaining to them what the master trust is. So the requirement for doing that and the form notice are part of the operating procedure that is on this slide. Um, they also, at the same time, required a notice about ABLE accounts so that there's a single notice to let people know to have a discussion with a child that some of their money can accumulate and be placed into an ABLE account for their future reporting, future use. Let me see. Jorge, can you show us the poll results, please? Okay, well, so um, So this would be a good question to find out from your kids if they're getting this new notice. If it's not been on your radar before, please put it on your radar to check in. Do they know? Do they have an account? And you can seek in a report, an accounting of how the what money has come in and how it's been spent. You can seek that at any time. So if you don't know, now is a good time to ask, right? Is it there? And ask your kids, do they know if they have one? So. Thanks, everybody. All right, another new thing. The notice should be included in the. Oh, I don't know if the 7-day notice should be filed with court. You'd have to look at the operating procedure to see if it's required. I don't know off the top of my head, but they definitely notices and reports should be included with the JRs at least twice a year. And it's certainly if you want to take action or bring something to the court's attention, absolutely you can file it with the court. Another somewhat recent change in master trust is that it was extended to age 23. So when Florida extended foster care, that was back in 2013, they did not change the rule on master trust, and master trust ended at 18. They have since amended the master trust document to permit funds to be retained and managed by the department as a representative payee up through age 23, because that would include young people who are in PES up until that age. For adults, it is voluntary. So my question to you is to inquire if your young person you're working with has, as an adult, has their money going into master trust. Did they uh, did they voluntarily agree to put the money in master trust, or were they coerced into agreeing it? Especially, these should be, many of them are young people who have disabilities. They should have their own attorney. They should certainly have a guardian ad litem. They should have had the opportunity to confer with their attorney to get independent legal advice before signing an agreement of that magnitude. So, check in with them. It may be the right and perfect thing to do. I'm not making a judgment about whether they should or they shouldn't, but like all of these things, it should be an informed decision that's made by the young person. So that is one of our practice tips. And yes, does the child turning 18 have to agree to keep the master trust? Yes, when they become an adult. Now, in some situations, the Social Security Administration will not allow the child to receive the money on their own. If they have a disability that that the Social Security Administration thinks might impair their ability to make decisions, they may require that someone be a representative payee. And in that situation, hopefully your young person has a trusted adult who can become the representative payee. There are also commercial representative payees that are apart from the Department of Children and Families. So there are options. And that has to be explored on that case by case basis. Okay. Just the slide has the citations and Not sure that the statutory links are great, but the rule links should work fine on those. Okay, so that was that question about should there be an alternative representative pay? And that's not just for kids over 18. You can, in the system, say, recommend that someone should be a representative pay other than the department. They may be charged a fee, and there are details in the operating procedure on that. But that is a fair question to ask, depending on the situation that your client is in, that might be appropriate. All right. This is where the controversy comes in because under Florida law, DCF is required to take money from the child's income and pay itself for cost of care. The cost of care is defined in the administrative code provision on this slide. It includes the room and board. I still don't know what child placing agency fees are, and other services that are paid for by the department that weren't covered by Medicaid. So that's the definition of cost of care. The statute, and this predates, I think even or came about at the time of the creation of the master trust, requires the department to collect fees for services that it provides. That's in 40233. They are required to do that. Then they have the claims for care and maintenance. That's room and board. That's the daily, meeting the daily needs of the person that's in their care, is considered to be a fee that is chargeable to the client. And so you'll see in the administrative code provision at the bottom of the slide, after leaving aside the monthly personal allowance, we'll talk about that in a minute, the lead agency then has to submit the remaining funds for the full cost of care to the department. So the CBC is doing the work to manage the master trust, but they do not get the money from the master trust. The money is paid into DCF. And this is a requirement that they do. But they mentioned the personal allowance. It is currently set in the administrative code at $30 for each federal benefit type. And that is, so if you get a Social Security death benefit and SSI, it would be $30 from each source. That stays in the child's account. Personal allowance is different than the allowance that children are paid monthly or weekly that we talked about in the beginning. Every kid in foster care should be getting an allowance. In this terminology, it's confusing because it's the same words. Personal allowance is the amount that has to be set aside to accrue for the needs of the child. So if the child gets $976 in SSI, but they live in a group home that costs $1,600 a month, then all of their money goes to the cost of care, except for the $30 of personal allowance that is left to accrue. So after 10 months, there should be $300 there that the child can access. So that's what that personal allowance is. But just because the cost of care is required to be deducted does not mean that all children are responsible for paying for their own cost of staying in foster care. They are not liable for the fees that accrue, and their wages cannot be taken. And this was in some of the states, they were actually taking children earnings from jobs to pay for their cost of care. Explicitly, Florida does not do that. And the debt does not rack up to the child. They don't owe money when they exit care. It's just on a monthly basis. The cost of care is deducted from what is received each month. And Stephen has put in the answer to child placement fees, administrative costs. That's still a pretty big black hole of what administrative costs are. One of the main reasons that cost of care payments were instituted in the statute was to make sure that assets did not accrue and to excess so that people lost their benefits. So again, it's $2,000 asset limitation for SSI. If you end up with $2,500 in the account, boom, you lose SSI. And for people who are not getting the child welfare related Medicaid, if you're doing an asset-based Medicaid, you could lose that as well. So the concept of why the state chose to do that is in part protective. I know it doesn't seem protective. It seems like they're taking the kids' money away, but it's protecting asset access to future benefits. Um, so, and let me just back up a second. So while they take out the cost of care, there is the escape valve to access more money. So when we're going to talk about that in a minute. So it's not that they just always take all of the money and the kids left with $30 a month. Florida has a safety valve. All right. So this is a really important practice tip when you are looking at the accounting. If you find out your kid has a master trust account, you want to know what's happened with it, make sure that it's accurate. The cost of care that wasn't paid shouldn't be deducted. Now, if a kid's on a run for a couple days and the group home has held the bed, that's a reasonable cost to be charged. But if the child didn't spend one night in the entire month in the group home, the cost of care for that group home should not be on their accounting. Um, and so this is, again, I don't ever think it's intentional, but people make mistakes. They're not on top of it. So you want to double check and make sure what is charged is correct. They may be charged, the cost of a group home, but in fact, the child was moved to a foster home with a much lower board rate. So this is the current base foster rates that are in statute. So that's just a guideline to find out, what's a reasonable amount. Also, if there's another entity who's responsible for paying for the placement, the cost of care should not be deducted from the child's master trust. So these are good things to just stay on top of so that you know that the money is being accounted for accurately. And then next, there's a requirement to have an expenditure plan. So please let me know if you have seen one for every child with master trust account. So Florida statute requires the state to balance the short-term and long-term needs of the children in care. And so when they're looking at taking the cost of care, that's the short-term need, right? Um, but it has to be balanced to against, and again, this is in statute, what their long-term needs are. So I want to just back up a second and like put you in the mindset of what the intent of that money is. So when SSI money or retirement money, I'm old, my husband's older. He took retirement as soon as he could when he was old enough because we have young children. So every month he gets a Social Security retirement benefit. My children get half of that benefit. Um, mm, for my one son, that benefit, half of it pays for his Chipotle bill in a month and pays for school fees, it pays for clothing. I don't have the luxury of taking that money and just sticking in an account for his future that pays our mortgage and our utility bills, right? And when SSI money is provided to a parent, it is to take care of the current needs of that child. And so we never expect a poor parent to take the SSI money and put it in a bank when they need to pay the rent and they need to buy food and they need to pay for the electricity. The point of that is to take care of the current needs of the child. And that's how it's used when children come into care. The state is providing for that care. The money is intended to pay for that care. And that's why I think cost of care is a reasonable deduction. But it also has to be balanced with the long-term needs. So the planning and budgeting function is in this section of the administrative code that I've put in here, and it requires some thought. And there's actually a form called an expenditure plan where you're supposed to think about what those current needs are, what those long-term needs are, what the individual needs are of the child. I have one kid in band. He needs band fees. I have another kid in Boy Scouts. He needs Boy Scout fees. Those are, it should be related to the child, the needs. If children have disabilities and need assistive devices or things that Medicaid doesn't pay for, those are the kinds of things that can be in the expenditure plan. And so there is a form that can be filled out and should be in the child's file. Um, there is a form to use to request withdrawing money, and that could be withdrawing money to send them to a week of winter break camp. It could be to purchase special clothes for the prom. Um, so, and oftentimes case managers will fill out this form. Guardian ad litem or child's attorney can help a child fill out the form. In those processes, there is also a requirement to notify um, uh, I'm sorry, for prior approval from DCF, if a purchase or a group of purchases total over $1,000, and when a single purchase is 500 or more. So that's a fairly new requirement to get a prior approval for that. There's a notice requirement to the parents, the GAL, the child's attorney, um, and also requirements for the accounting. And the concept here is noted at the bottom is function as a prudent parent who keeps their eye on the day-to-day needs and the future needs. So Jorge, how did we do in the poll here? Have people seen expenditure plans for all their kids? Never. Holy cow. All right, let's get on it. Start asking for those plans. Check if they're in the file and you just didn't get a copy of it. Um, Yay to the one person who always sees them. But this is just, it's like a normal planning function. How do you even know what's happening with your money? And, you know, is there a plan that the kid had the input into? Um, so in current needs, there's a list here that is from the administrative code provision. If they have needs for electronic devices, it would be nice. We try to get them to put phone in here specifically, but phones would count in that. Um, Travel to places that they need to go. Those are things that can be considered as part of their current needs. Okay. Um, Long-term needs, this is where we start to really think about that transition to adulthood, that they're going to need money when they exit care, whenever that is. They might need, you know, household goods, um, things to help them with work. You know, it's what's going to assist them going forward in the future. How do you balance that out? So, um, now that you know to look for a notice of expenditure, take a look at it. What's in the plan? Um, what has money been withdrawn for? Are kids involved in the decisions about spending their own money? Did they get the information and the notice when big purchases were made? And as did everybody else. So those are just things we want to keep everybody on the up and up, staying on top of what's happening with the money in that account. Um, okay. And then we're going to talk about the waivers. So while we're talking about it, go ahead and answer the question. And this is for here, waivers. We are talking about um, having access to the money in the master trust account. The word waiver is very generic. It applies to a lot of things. This specific poll is asking if kids are able to access the money in their master trust account using the waiver process. Okay. DCF CBC is required to have a process to apply for the funds. Again, we talked about this is the children's money, and for the state to take it, they have to provide due process of law. So we have the notice of fee assessment and rights of the child, a specific form. And then because it's a fee assessment, they have an application for review of assessed fee, also a form that's filled out. And that is the form, which I'm referring to as a waiver, but that is the form that children and the people working with them use to access their funds. And it is an actionable action. So if the request is denied, there is an appeal process under Chapter 120. So this is the form number that is used. Again, DCF has to give prior approval for total purchases of over 1,000, or if a single purchase is 500. And it goes to, I believe this is still accurate. DCF sometimes changes things on me, but I think it's the Circuit Community Development Administrator who reviews that request. So what you're asking for in that application is to either reduce the cost of care or increase the allowance. So it's saying, hey, I know you can take this much money from my account every month, but could you please take less money or maybe take no money so that my account can build up because I want to spend it on a specific thing. And anecdotally, when I've talked to folks who have done this, they tell me that their requests are not denied. Let me rephrase that. Requests are granted unless there's not sufficient explanation and backup documentation to show what the money is for or intended for. So if you just say, I want more money because I want to have more money in the account so I can spend it when I'm ready to spend it, the answer is probably going to be no. If the request is, I want to take the spring break summer trip to Costa Rica with the other children in ninth grade class, it costs this much money. I'd like to accumulate the money over the next 4 months to be able to pay for the trip. Chances are much greater that it will be accepted. So having the detailed reasons, having you need to know what's in there, what you're asking for. That is, the increased likelihood. Okay, so can they buy cars with it? Yes, that's if you want to, I want to save the money to sign up, to buy a car. Now you get the issue of the $2,000 asset limitation if it's an asset-based benefit. So if it's a veteran's benefit, there's no limitation. You can just say, I want to, leave the money in my account until there's $6,000 there so I can buy a used car. Or I want to make an alternative arrangement. I need, 2,000 for a down payment and then $400 a month to make a car payment. Absolutely, those are appropriate things. The allowance, does that stay in master trust like the savings account for when they need it? So the personal allowance in the master trust account is just treated as the money in the account. So you have to make that, if it's in there, then you just using the withdrawal form, you withdraw it. So yes, I guess, Marianne, it stays in there like a savings account for when they need it. And it's only if there's not enough personal allowance that you have to ask for extra money that you would use this application for review of assessed fees. Um, um, who pays for court costs when appealed attorney's fees? I don't understand that question. Maybe I've missed something in the discussion. If anybody else who's been following it can answer, or if you give me more details, or maybe we could talk about it afterwards later, because I'm just not sure of the context for that, Rosemary. So so Jorge, how do people answer? Do their kids get it when they request it? Okay, well, I like always, mostly and sometimes, and I'm sorry to hear about the seldom and never. And I would say if you see that as a repeat concern, I'd really like to talk to you about that and see if I can help or one of my colleagues can help get those applications in shape so that kids can have access to their money, because that's really not cool. So if we're not filling out the form right and we can fix that, that's fine. If there's a systemic issue where people are being denied, that's problematic, and we would surely like to help with that. And for those that don't have any idea, I hope you'll find out in the future, because it'd be good for kids to have access to their own money. So when you are applying to have, this money accumulate in your account, there is a committee of 3 people who review that and have to act within, they have to make a decision within 10 days. DCF has to review, they're supposed to act within 5 days. And then there is the administrative hearing process. So I don't know whether DCF fixed their form. The rule says that the appeal of a denial has to take place within 21 days. The form, when they first published it, told them that they had 30 days to appeal. Hopefully they fixed that, but the rule says 21. Um, do um, do they have to have court costs for taking the appeal? I'm not sure that there is a filing fee or court cost. And there's no provision to pay for an attorney for a child to take an appeal. Um, so it'd be great if the kid already had an attorney who could do the appeal. Um, but if there's a court cost, I would think they would be eligible for a waiver, but I don't have any other information on that. It's a good question, Rosemary. So this is the criteria that committee of 3 is supposed to be taking a look at. And, sometimes people apply for this without including the child, and that may be appropriate for younger children, but really with our older kids, they should be involved in how their money is being spent and be able to establish their needs and desires. So hopefully you will include them. So this is important. The effective date for the request can be retroactive to the date of the creation of the account if the request is made within the first 3 months after the account was established. So if your child is newly accessing a federal benefit and they have an ongoing need that you want that money to be used for, if you make the request within the first 3 months, it can go back to the beginning. So, for example, if your kid has SSI and they really like to go horseback riding and they are enrolled in a after school horseback program that costs $100 a week, and the foster parent paid out of pocket to get them enrolled or somebody funded it, but it's something that they want to do going forward. You can early on say, please save $100 a week to pay for horseback riding out of this SSI money. And even if it takes a little while longer, it can go back retroactive to when the account was established. If your kid's been in care for a while and they're asking for money on a going forward basis, the effective date is the date the request was approved. DCF has given direction to the CBCs that if they receive a request, they should stop deducting the cost of care while that process is being figured out so that there's enough money there to fulfill the request if it's granted. I don't think it's a requirement, but it's a suggestion to help smooth out those financial issues going forward. And again, the CBC isn't getting the money. DCF is going to get the money. So if they're saying it's okay to hang on to it until we work it out, hopefully they will do that. So practice tip, check to see if the notice has been given to the young person. Um, and it's both should be in the file, but you should also ask the kid, have you gotten this notice? Talk to their guardian ad litem, their caregiver. Um, is this notice coming across? Are people aware of it? So to be clear, when the state fails to do that, it's an unconstitutional taking of property without due process of law. And a refund can be requested. It's been several years since I've had one of these come across my desk, but we've had situations where we could document that the child never received the notice, had a specific actual need that was unmet because they didn't have access to their own money or knowledge of it. And we have seen CBCs refund children's accounts, I think up to like $3,000 in one situation. Better to stay on top of it. But if the mistakes have been made and you can show that the child would have asked for and received the waiver, you may be able to get the money back. So, and then, check in with your kids. If a waiver was sought, what was the outcome? Um, and was that decision justified? And if it wasn't, if you feel like the kid should have gotten the money and they didn't, like I said, we would really like to help in those cases because we want the kids to have access to their money. Okay. So the next thing that the state is obligated to do is to issue the funds when the child exits care. So this is an explicit requirement of Florida statutes. It contradicts what the Social Security Administration preference is, but Florida law is Florida law. So ask for a court order on how to dispose the funds if the children exit before 18. If they exit at 18, the money is to be provided to the child unless the child is incompetent or incapacitated, in which case DCF can seek an order creating a trust. Hopefully, for those children, the Regis Little Act has been activated, and if they have decision-making impairments, some other arrangement has been made to help them with their decision-making as an adult. So there's a memo from DCF regarding changes with regard to the Social Security, where DCF is supposed to seek approval from the Social Security Administration to support transferring the funds to the child. I don't, this memo came out in 2011. I'm not sure how that's being implemented right now. If anybody's had experience with that, I would be really curious about your experience and like to know what your thoughts are and if that's actually happening. So again, the Social Security Administration wants the money to be returned to it and then sent back to where it belongs. That can create a substantial delay in whether it's the adoptive parent or caregiver, the parent if the child's reunified, or if it's the child turning 18. Getting sucked into Social Security Administration can take a lot of time before the kids get it back. So try to push for the money to be issued appropriately at the time the child leaves. So must the child be dispersed if they're in extended foster care? So that goes back to the child's choice as to whether elect to stay with master trust after 18 or not, and whether that was a reasoned and counseled decision. So if they choose to stay with the master trust, then no, the money is not dispersed. If they ask for the money out of the master trust, then yes, the money should be dispersed. So follow the money. This is a document that DCF issued, and it was on the DCF website, and it's kind of directions to staff about the timeframes for different actions that it needs to take. So the interesting thing is DCF has had a web page called Master Trust that had a number of resources available on it. And when I looked at it a couple weeks ago, I pulled some things off. When I went to look at it 2 days ago, that web page is down. So I'm not sure what's happening within the system, but there's some documents like this that are included in the materials that we will be sending to you. So you'll be able to see this online and live. So last poll to launch. This is not a this is a short answer poll, not a multiple choice. And while we're wrapping up, we would love your thoughts on what other subjects you would like Florida's Children First to do training on. So sorry you all won't be able to see each other's answers, but we would appreciate your input. So our contact information is in here. So we went through a lot of material fairly quickly. I think I've answered the questions that were that came up in the chat, but there's time for more. So if there are other folks that want to chime in, or hey, did I miss anything? I can go back and look. Let's see.
I think you covered them all. There's one that just came in from Suzanne. Must the funds be dispersed to the 18-year-old, even if
That one I
they're,
addressed. Yeah, that one
yeah,
I
I
talked
was
about.
dealing with the poll and I must have
Yep.
missed it. Okay.
But let me go back because there were, okay. Who does one contact when the CBC misuses the master trust fund? So, master trust can be used to pay for medication or food that is not otherwise covered by Medicaid. So if Medicaid should have paid for it and somehow there was a screw up for a specific period of time and it wasn't, Medicaid wasn't asked to pay for it, then I would make a request to the community-based care lead agency requesting that they refund the master trust account and the amount of the money that was deducted. I can't imagine why peanut butter would need to be paid for out of a master trust account. We feed children. That's, if there was a specialty food or item that was expensive, that was not covered under Medicaid, that might be an appropriate thing. But if it's covered by Medicaid, it should not come out of master trust. And again, I would start with the CBC. And, you know, I would probably do their general counsel, executive director, and make the case there. There was a question about whether master trust could be used to pay for legal fees or restitution. There's not anything that I've seen that would say that it could not be used for that purpose. So I would, if that's something hanging over a kid's head that's going to affect their ability to get their driver's license, do other things, you know, I definitely would ask for that. I think that's it. Like I said, sometimes questions don't really arise until you're in the middle of handling something. And, please just reach out and contact us and we will try to help you work through any of the problems. But otherwise, that's it. And I'll say goodbye and give you back 13 minutes of your life. Um,
About to end the poll to see what trainings people are requesting, but Robin, we have like 24 answers, so we might have webinars for the next 2 years. I'm just saying, I don't know.
Okay, great. Well, and there
So,
is another question came in about kids responsible for paying enhanced rates out of the funds. Yes, the cost of care is the actual board rate that's being paid. So if a foster parent's getting an enhanced rate, and then that is the legitimate amount of cost of care. So yes. But again, not that the kid is responsible, it's that the state is required to reimburse itself for the cost of care in that amount. And if the money is not in, if the kid gets $260 as a survivor benefit and their cost of care is $1,600 a month, they can't take more than that. Um, so Jorge will share your final subjects with us at Florida's Children First, and hopefully we'll come up with some great topics for our next round of training series. But in the meantime, we are back in January with, I don't remember what we're doing in January. I think
so
that
the
might
next one is Emancipation. I will
be,
drop the link to the to register. It's
right.
going to happen January 21st. So I will drop the link to register and the email that will go out from soon because I don't want to overwhelm people with messages in the chat. I did drop the CLE code. I just wanted to read it out loud for the benefit of the audience. The CLE code is 2516228N as in Nancy. So this will also be included in the email. I will include Robin's contact info, which is also on the screen here. And I will include a YouTube link to a playlist. This one will take me a few hours, maybe a day to upload to YouTube, but every single training of these series I've been uploading it to that playlist, so you have them all in one place. In case somebody that missed the registration link, I will also include the next one, which is coming up on January 21st, led by Janine Rice, who I saw earlier in the chat. So I know she's here. Thank you, Janine. All right, so I don't see any
Thanks,
other
everybody.
questions other than a lot of thank yous, Robin. I'll be sending out those certificates. And I guess this is the last webinar. Not only of this is for this year, but we still have the series that's ongoing. So I will share the all the submissions for the training requests. I will have to pull that out of Zoom later, but I'll make sure to share those with you, Robin. So any final statements before we wrap up, Robin?
Happy holidays, everybody. We'll see you next year.
All right. Bye bye.
Bye bye.